In the 1976 case Gregg v. Georgia, the United States Supreme Court held that the death penalty isn't a per se violation of the Eighth Amendment's prohibition on cruel and unusual punishment. However, the court advised that state death penalty statutes should provide bifurcated trials with separate sentencing proceedings, mandatory consideration of aggravating and mitigating circumstances, a right of automatic appeal, and a proportionality review. But what if a defendant waives his or her right to appeal a death sentence and chooses execution? In the 1976 case Gilmore v. Utah, the court addressed this question of waiver. On October 7, 1976, following a jury trial in Utah State Court, Gary Gilmore was convicted of murder and sentenced to death. Afterward, Gilmore demanded that his attorneys not file an appeal or stay of execution, despite being advised to do so. In fact, Gilmore's attorneys informed him that he had substantial grounds for an appeal and that the constitutionality of Utah's death penalty statute could be challenged. Further, the court itself reiterated that the statute's constitutionality hadn't been resolved and that counsel for both the state and Gilmore would expedite an appeal to avoid any delay. Nonetheless, Gilmore repeatedly stated that he had received a fair trial, was well treated by the Utah authorities, and didn't profess innocence. His only complaint in the process was the delay in carrying out his death sentence. On December 2, 1976, Gilmore's mother, Bessie, acting as Gilmore's next friend or his legal representative, filed an application for stay of execution with the United States Supreme Court. The court granted the stay to secure Utah's response and the full transcripts. 6 days later, Gilmore filed a response to the application, challenging Bessie's standing to initiate proceedings on his behalf and stating that he opposed a stay to his execution. The court examined the application for stay of execution.